Out of four, Chief Justice get to Torkornoo, the suspended Chief Justice no. Justice see a meno Casano, or the case Nasa ECOWAS, out of four. ECOWAS court or my dismiss case na because in some my banner dear, just Osha ECOWAS court or more bed dismissing the case now, or the Aquaco Piemu, Abuja, Nigeria, or for my call, na yanko this answer when you na in Chim and Radisia, Ghanatube so.
The point that Kwekwan Sansar is going to be joining us on Zoom briefly. There's a point he made about the ECOWAS court recognizing the internal structure, as it were. They would also look at whether she has exhausted all the internal avenues for remedy.
So is the African Court on Human Rights
before anything else? Is that in tandem with the dictates of the statutes of the ECOWAS court?
No, not the ECOWAS court. The ECOWAS court is very clear. I've read at least 2 decisions where they've said a case before a domestic court is not a bar. The ECOWAS court has been very clear. This one is beyond argument. Maybe we are mixing it. What the ECOWAS statute says is that if you have a case before another international court, so let's say you have a case before the ECOWAS court, then you run to the African court. They say international. We can read them if there is time. No. If there is time.
We'll pull it. But yes.
As for the domestic one, so like for the lawyers who are interested, if you Google it, you see this case. The registered trustees of Heather Resource Center, okay, Human and Environmental Development Agenda versus the Republic of Nigeria. Let me repeat it because lawyers, I mean, we are all giving education. It says the registered trustees of Heather Resource Center, Human and Environmental Development Agenda versus the Republic of Nigeria. If you want, suit number ECWC/CCJ/APP/40/21. Okay, and the judgment 2024. Or if you want, just Google simply. It's a case pending before a domestic court, a bar to the institution of another case in the ECOWAS court. You will see, you'll find it now. As you keep digging, you'll get the judgments. So that one, there is no argument at all. You don't even need to show that the domestic court will be unfair, they will be biased, political, that it is illusory. No, they just say it is not a bar. But maybe out of abundance of course, you want to show why the domestic court is not one. If you like, I can read this last line, but that's extremely clear, okay, that it is not a bar. Let's not go and say something that, so listen here. It says, so the case I just read. Yeah, okay, let's read. It says that the court held in registered trustees of the Socio-Economic Rights and Accountability Project, SERAP, versus the Federal Republic of Nigeria and one other. That's 2016 CCJ-ELR at page 433. That where a case is lodged before the local judge under the domestic court system of a member state, there is no bar on the community court entertaining the same case.
You are absolutely right. You know, you can look at that.
Even the
case clearly tells that that's consistent with what Ghanatube read. Now, our quick search shows that what you're saying is correct.
Yes.
That no, the fact that a case is happening at the local level is generally not a bar to go into the ECOWAS Court of Justice. That is what our search, how you just put it. In fact, I encourage our listeners to also do so. You get it. Yes. But this way.
Out of 4 months in seminar course, you see, say everyone say, oh, case. Na say everyone say, oh, local country, no. Di wa asema eni kwan say utumi pega case no biom esanso de the international level. Nti everyone say, oh, case, whenever say bia Chief Justice get to Torkornoo case na ekos wo Ghana ha say no. Yenya ndi case ni wie enti oni ho kwan say also page case no ko different country international level that be yes say oh yes na wa from mrano say ECOWAS court na nkasa enhyehyɛ na ba ni na to dwama mo yes say wo case be pending in your country any kwan amundi asem ni wie ya any kwan say otumi kuku sa case na record another level another say we kuku sa case na record different country na different international level yes oh yes na etiam brand to for wa hwe the way I see nyama si koni da just say chief justice get to Torkornoo no ne nsem ni nyina na odeko ECOWAS court no ye bebu egu ba o so for manko na yentu ansem so embrace ya e Ghanatube so
bring in let's understand the basis for Kweku Ansari's position, right? So then if you have to bring in your point as well, Mr. Kweku Ansari is a former director of the Ghana School of Law. He's joining us on Zoom right now. But you've been listening. You hear Lawyer Martin Peeble's position about the position that you held sometime last week when I spoke to you off record. You had indicated that the ECOWAS court will take into consideration whether or not the applicant before them has exhausted all internal avenues of redress. Correct?
Well, she exhausting internal remedies simply means ensuring that the proceedings have terminated to completion. They have, gone through every step. You see, she is preventing the steps from being implemented. So she hasn't exhausted. She cannot be said or cannot be argued that she has thereby exhausted, the internal remedies. No. So merely, inundating the court with, incessant applications is no meaningful reason to suggest that she has, exhausted the internal remedies. She has been filing application upon application, and if you look at the nature of the application that have so far been usually considered by the High Court and the Supreme Court, you see that they were wholly, factually, and legally unmeritorious. And if an application is without any merit, the obvious outcome is a dismissal. It will be refused, and they have been refused. And when she launched the first one, you recall that on one of your shows, I indicated that she can file millions of applications, but insofar as Article 146 is concerned, the provisions stand guard over any such application. So we may file repeated applications. They can only create ugly noises in the courtroom, but applications ultimately become a social nuisance. Legally, they are incompetent, and for a Chief Justice, bringing application upon application and being told to their face that the applications lack merit is not good for her own image. It is not good for the general public. It is not good for Ghana as a nation. That our Chief Justice will file an application that a committee, will assess, evaluate, and see.
But then how do you see this case playing out from where you said? What outcome do you expect of this case, taking into consideration all you have just said at the ECOWAS court?
One of those, cases, I think, that be a return match. They will ask her, they will answer to come back to Ghana. I don't see how the ECOWAS court can change our rules of procedure. Our rules of procedure are, firmly embedded in the High Court rules, with the support of, the Evidence Act of 1975 and RCD 323. They are there. It is a procedure for, Ghana. It is not the procedure for ECOWAS. It's for Ghana. And ECOWAS doesn't have, a West African sub-regional procedure. that we are applying and violating. It is our own rules of procedure and evidence that we are applying, and therefore, taking the matter out of the purview of our court to the ECOWAS court is not going to achieve the desired, purpose. I think it will be defeated, and at the end of the day, I think that upon a sober reflection, the Chief Justice will realize that she has shot herself wrongly in the foot. No one else. So she's making her bed and she's lying in it, and it saddens and pains me that she's adding more insults to injury. I've said elsewhere that.
Right. And that point that you made, and that's where Mr. Congress are bringing. So, people, that's some detail to the position that he took. That ECOWAS court cannot necessarily change the rules of engagement, essentially, if you look at it. But then again, he still holds the view that there are a number of applications regarding this matter, and you see the Deputy Attorney General reference it as well. That some of the issues he's seeking as reliefs in this application are also being tried already. Here. So why not wait for the outcome before going?
Yes, so as we said, the ECOWAS court is saying they can also look at it. And don't forget that, you see, in law, as we, in human nature, we are different. Some people are conservatives, others are liberal, some are in between, etc. We should bring the psychologists. I keep saying that that's one area we don't pay attention to. Sometimes we just see human beings and we think everybody is good or everybody is bad. No, but there are differences. So in the same way, in law, there are various philosophies. So you hear the textualist approach, the purposive approach to interpreting statute, constitutions, etc. Right? Yeah, so to that extent, a case that you may see as bad here, it's possible in the other forum, they may see it as good. You say, so me, I don't want to say anything about the substance of her case. No, as I've said, she's struggling already, right? I mean, the torture, okay? The torture is a lot, and you see that's how come I've repeated here several times that if I had my way, I would have seen if we could have mediators come in and see how she can be allowed to exit with a resignation. Because now you see where we've been taken to ECOWAS court. So those things have been published with the ECOWAS court. Who knows, from ECOWAS court, maybe she'll go to the African court. We don't know where else. So by the time we are done, all of us would have been fully dragged in. So sometimes, I mean, if you give the person an exit, for me, what is clear is that once it's an exit to go, fine. Okay. But not an exit that come back, no. Right. No, that one I'm very, very clear that no. These are very serious matters. Either we go into the details and get merits, or she should be given an opportunity to leave, but not the one that come back and occupy the position without us going into the case. Okay. As for that one, if she wants to come back into office, then let's go into the case. Okay. Okay, because those are very serious matters. We can't sweep those under the carpet. Otherwise, our democracy will not grow. So that let's be very clear. Indeed. So
other four when sema abetu dwa yesi ECOWAS court no by and by no obe reject Chief Justice and that suspended Chief Justice get to Torkornoo ni case no dey call yesi by and by obe reject case no because yesi case ni edin wo Ghana ase mra no say wudi case wo Ghana ase and so wudi case bi o country bi a eni kwan say case na ye ndin wie eni kwan say okuku edeko another international level. Inti just say we tear emra anase wa form omra no nti enya ade a emra no ebeko ede ama no dofo we na ebekini so beto jam so bi ni nyina brew ewo Ghana Chief of Memory Office be like na ma subscribe no ma share no ma hit notification bell so ma say na be ya abrini abibia do pay content a wo wonya ne tempa no hwe mi tiam dofo aha ana me ne nsem nya besi makra mu nyina eda mu nyina se